This is from Brandon Benwell. Hi, my ex-wife and I suppose hi, my ex-wife and I were co-owners of a house. We got divorced and was rewarded the house. I'm not sure who got the house in the divorce. In the decree, it stated that she had to remove me from the bond. Okay, so I'm assuming she got the house
Yeah.
and transfer the house over to her name. She then disappeared and rented out the house. 10 years have passed, and I've been struggling to get a loan or credit due to affordability because my name is still on the bond and on the title deed. Last month, she got in contact with me because she wants me to sign as she wants to sell the house. My question is, can I sue her for not taking my name off the bond? Thanks.
Sure, I'm sorry. I think I'm getting that one. I have a bit of experience in fun things around divorces. So the truth is, your decree of divorce will definitely deal with how things should happen. So if you got divorced with a settlement in place, so that's obviously the ideal way of doing it to avoid all the drama around divorce, because it does come with its own level of drama that, as you can clearly see, might follow you for 10 or so years after the actual divorce. But um, the, if you had a settlement agreement and it simply said your ex-wife's going to get the house, she must remove you from the bond, and nothing specific else around it. Remember, it's still a court order. So she has to do what the court told her to do. If she doesn't, you can either, if it's, say, for instance, for money or something, you can issue a warrant of execution, get the sheriff to go and get it. Or in a case like this, you can bring an application, probably more likely for contempt of court than anything else. So you will place on terms and say, Jong, I'm still on the bond. You need to remove me in X amount of days or months or whatever. If you don't, I'm going to bring a contempt of court application. And as part of that application, I would probably advise that we bring in a prayer to allow the sheriff to do that on her behalf. So that's usually what we do. If somebody has to do something, not just pay money, and they're not doing it, usually as part of your prayers, you will ask the court to authorize the sheriff to act on behalf of the person that had to act, that's now not acting. However, the fact that it's been 10 years, unfortunately, means that you've incurred quite a few expenses potentially, and obviously risk and stuff, but you won't be able to sue for damages because you had another remedy. We always need to follow the first available remedy, and you already had a court order in place. So the better remedy would have been to institute those proceedings. If you sue at this stage for damages, the defense from the other side would simply be, but there was a court order and you didn't enforce the order. It would be difficult to get another order on top of an existing order, because you wouldn't have suffered damages if you followed the correct route. But now, then again, I do appreciate that because we lawyers, we know exactly how to do it and when to do it. And there could be something in that. But the truth is, litigation in this respect is going to take you another 2 to 3 years if you get into that. And I don't know about you, but from my experience, less interaction with your ex-spouse is better than more. So I would probably advise a client to not fall into further litigation and simply at this point demand that she removes you. But the fact that she now wants to sell, I would demand that she remove me prior to the sale. Because if you sell and there was new expenses and stuff incurred, rates and taxes, things like that, at the point of sale, and you are still a co-owner and a part of the bond, you are at a massive risk. So I would jump very quickly on it, demand that she remove you prior to the sale, and say that you will not agree to the sale. So she has to remove you, and she has to transfer. In terms of a divorce order, it's a 42 biz transfer. It's a very quick, simple transfer. It's quite cheap. So she will have to do that. Part of that will remove you from the bond, because you can't be part of the bond if you're not co-owner. So all of that is done. So I'll approach a conveyancing attorney quite quickly. Obviously, both Bruno and SSLR, we all do that as well. So you're welcome to contact one of us as well. Let's do a very quick transfer, remove you as owner, remove you as bond, and then she can sell. But my advice is definitely don't sell and don't agree to a sale as part owner. You are at massive risk. Bruno, am I just paranoid of that?
No, absolutely. So because obviously the easiest solution is to say, look, sell the property and co-sign a seller. But now you need to remember with the, like with the disclosures that you need to do regarding the condition of the property. Any recourse that a purchaser will have against you in the short term and the long term. So, I mean, what's the odds? So you're looking at within the first 6 months, a lot of purchasers raise issues when they buy properties. It's a simple fact, because they finally get to move in, and all of a sudden there's cracked tiles, this, that. And, the question is, did you know? Did you disclose it? And it becomes a thing. So 6 months, if the purchaser really wants to, you can make your life misery. Now you co-seller. Can you indemnify yourself from it? Yes, you can. The problem is that the indemnification, for the most part, would only be between you and your co-seller. As soon as you try to tell the purchaser, I indemnify myself, the purchaser starts panicking and freaking out. So just bear that in mind. So yes, there's a way of doing it. You would be able to get away with co-selling, but there's a risk. And there's certain undertakings that you'll end up making that as a co-seller, it's a bit dangerous. Were you to do your due diligence really, really well, maybe, but then you're going to need to do it almost perfectly to make sure that you don't undertake any extra liability. The other issue that I sometimes experience when it comes to things like this is the court order can say that the property is supposed to go to her. The removal of the bond is a different story, though, because the removal of the bond involves a third party that's not directly involved in the litigation proceedings of the divorce. So sometimes I find a few issues when it comes to going to the bank and saying, hi, please remove me as a borrower, because the banks will sometimes say, well, okay, fine, we'll remove you officially as a borrower, but we're retaining you as a surety. So you're still going to be liable. So I find that sometimes divorce orders are not really in line with the real world scenario of how lending works. So, take note. You might find it difficult to remove yourself as a borrower if the bank doesn't find enough security in the property or in your ex-wife being able to repay without you. And that's just something I thought I'd throw in there.
Yeah, I think it's relevant. And I think it's important. Very often attorneys are so quick to jump to the law and what can be done. But the complexity of something like this, where you want the parties to have as little as possible interaction, especially 10 years later, would change the advice that you give. My advice would have been different if it wasn't ex-spouses, but business partners, for instance. It would have been different.
Absolutely. Yeah, absolutely.